Following our discussion of adverse possession and the laws governing ownership of vacant land, we now turn to another area where property rights can become complex: crop rights on farms. Arizona's agricultural lands are a significant part of the state's economy and culture, particularly in rural counties such as Pinal, Maricopa, and Yuma. These lands present unique legal considerations that arise when ownership, possession, or use of the land intersects with rights to the crops growing on it. Understanding how crop rights function in Arizona, real estate law is essential for agents, brokers, and property managers involved in transactions that include farmland, leased agricultural property, or undeveloped land used for cultivation. Crop rights refer to the legal ownership and entitlement to crops growing on land, whether the crops are currently planted, growing, or ready to be harvested. These rights may belong to the landowner or to a tenant farmer, depending on the terms of ownership, lease agreements, or statutory law. The distinction becomes crucial when land is sold, foreclosed upon, or transferred, as the crops, while physically part of the land, may be treated as personal property under certain conditions. Under Arizona Revised Statutes, Paragraph 47-107, Uniform Commercial Code Article 2, growing crops are considered goods that can be owned and sold separately from the land itself. This means that a farmer who leases land to grow cotton, lettuce, or alfalfa, for example, has an ownership interest in the crops they plant, even though they do not own the soil beneath them. However, if no lease or agreement specifies crop ownership, the crops are presumed to belong to the fee simple owner of the land. A classic example of this principle occurs when a lease expires, but the crops are still in the field. If a tenant has planted a crop in good faith before the end of the lease term, Arizona law and agricultural custom often allow the tenant a reasonable time to harvest those crops after the lease ends. This concept, sometimes referred to as the doctrine of emblements, is rooted in both common law and fairness. The doctrine protects tenants who invest labor and money into planting and cultivating crops that have not yet reached harvest when the tenancy ends unexpectedly. The landlord, therefore, may not simply claim ownership of the crops unless the lease explicitly says otherwise. For example, imagine a tenant farmer in Casa Grande who leases 200 acres for 2 years to grow alfalfa. 1 month before the lease expires, a final crop cycle is still maturing. If the landlord chooses not to renew the lease, the tenant retains the right to re-enter the land to harvest that final crop. This protects the tenant's financial investment and prevents unjust enrichment of the landowner. Disputes can also arise when land changes ownership during a growing season. If a parcel of farmland is sold while crops are in the ground, ownership of the crops depends on whether the purchase contract or bill of sale specifies who owns them. Under ARS, paragraph 47-2107B, the crops are presumed to pass to the buyer along with the land, unless a separate agreement reserves them for the seller. Therefore, real estate professionals handling such transactions must ensure that contracts clearly state whether the crops are included in the sale price or remain the property of the current grower. Legal importance. If an item is not severed, removed, or specifically excluded in a sales contract before a buyer views the home, it is generally considered part of the real estate and must remain with the property. Crop rights may also come into play in cases of foreclosure or eminent domain. If a lender forecloses on farmland while crops are still unharvested, the borrower or tenant may retain rights to the crops if they were the party that planted and maintained them. Similarly, under ARS, Paragraph 12 Yogar 1123, when the state exercises eminent domain and condemns farmland for public use, the farmer may be entitled to compensation for lost crops or unharvested yield as part of the just compensation guaranteed by Article 2, Section 17 of the Arizona Constitution. Just compensation. Private property cannot be taken or damaged for public or private use without just compensation being paid to the owner first. The importance of crop rights is not only economic, but also contractual. In Kleck versus Wayland, 1963, an Arizona appellate court addressed a dispute where a landlord attempted to retain crop proceeds after prematurely terminating a tenant farmer's lease. The court ruled in favor of the tenant, holding that crops planted and tended by a tenant before termination remain the tenant's property, and the landlord could not seize them without due process. This case reaffirmed the principle that crop rights are tied to labor and good faith investment, not merely land ownership. The court held that growing crops are part of the real property, and when land is taken or damaged through eminent domain, the owner is entitled to just compensation that includes the value of crops destroyed or rendered unusable by the taking. The decision emphasized that Arizona's constitutional protection against taking or damaging private property without just compensation applies not only to the land itself, but also to improvements and appurtenances, including crops. Real estate professionals involved in agricultural transactions must therefore be aware of several key considerations. Lease provisions. The lease should clearly define who owns crops, who pays for planting and maintenance, and who is entitled to harvest profits. Sale contracts. The purchase agreement should specify whether crops transfer with the land or remain personal property of the seller or tenant. Disclosure and due diligence. Brokers must ensure that buyers are informed of any existing farming operations, crop liens, or agreements that might affect title or possession. Lien priority. Crop liens may exist for unpaid labor or seed suppliers, which can affect closing and title insurance. Understanding these nuances helps prevent disputes, protects client interests, and ensures compliance with Arizona law. It also reinforces one of the recurring themes throughout this course: the importance of clarity, transparency, and written documentation in all real estate transactions. Review summary. Crop rights define who legally owns and benefits from crops growing on farmland, and are distinct from ownership of the land itself. Arizona law recognizes crops as personal property when grown by tenants or others with permission, allowing them to harvest and sell their yield even after lease termination. Under the doctrine of emblements, real estate professionals must ensure that contracts and leases clearly outline crop ownership to avoid disputes during land sales, foreclosures, or terminations. Courts have repeatedly upheld the principle that the right to harvest crops belongs to the party who planted them in good faith, not necessarily the landowner. Discussion prompts. Why does Arizona law allow crops to be treated as personal property separate from the land? Answer: to protect farmers and tenants who invest in planting and cultivating crops, ensuring they receive the benefit of their labor even if land ownership changes. What is the purpose of the doctrine of emblements? Answer: it allows tenant farmers to harvest crops they planted before their lease ended, preventing financial loss from unforeseen termination. How should a real estate agent handle a sale involving land with growing crops? Answer: the agent should ensure the sales contract specifies whether the crops are included in the sale or remain the property of the seller or tenant, when they will be harvested, and who will maintain them. Closing remarks. Crop rights represent a delicate balance between land ownership and the rights of those who cultivate it. For Arizona real estate professionals, understanding these principles ensures fair and lawful transactions involving agricultural land. It reinforces the duty of care that brokers owe to clients, ensuring that every material aspect of the property, including crops, water rights, and leases, is fully disclosed and documented. The clarity of such agreements not only prevents legal disputes, but also supports the ethical foundation of the profession. Supporting sources and key case law. ARS. Paragraph 472107. Definition of crops as goods under the Uniform Commercial Code. ARS. Paragraph 33-931. Agricultural liens on crops for labor or seed costs. ARS. Paragraph 12, 11, and 11. Eminent domain compensation for loss of use in crops. Arizona Constitution, Article 2, Section 17. Right to just compensation. Kleck v. Wayland. 93 RSR 385. 1963. Tenant crop rights and wrongful lease termination. Doctrine of emblements. Common law. Protection of tenants' crop rights upon unexpected termination. ARS. Paragraph 33362. C. The landlord shall have a lien for rent upon crops grown or growing upon the leased premises, whether the rent is payable in money, articles of property, or products of the premises, and also for the faithful performance of the terms of the lease. And the lien shall continue for a period of 6 months after expiration of the term of the lease.